Welcome to the Case Bank 7-minute update featuring 14 of the 52 new summaries added to the database during January 2021. AB 1950, effective January 1st, 2021, amends PC 1203.1 to set the maximum length of felony probation to 2 years. Held. This is retroactive to all open cases. Case 2. Restitution for victims' legal fees incurred while getting a restraining order against the defendant is not permitted. Restitution for legal fees and gathering evidence to give to the DA is permitted. Restitution for legal fees and seeking restitution from the defendant is permitted. Total legal fees approved by the trial court in this case was over $200,000. Upheld. Case 3. Court of Appeal finds a draftsman's error in SB 1437 regarding changes to felony murder, specifically PC 189 subdivision F. Held. Malice is not needed for felony 187 if the victim is a peace officer in the performance of his duties and the defendant knew or should have known that. Case 4. San Diego has a boilerplate probation term requiring the defendant to notify the probation officer of any police contact that involved the defendant being questioned by the police. Held. This term is not vague. This term is not overbroad. Case 5. Hearsay may be considered and used by the expert evaluating the defendant for possible inclusion into the sexual violent predator program. Hearsay may be considered by the court at the probable cause hearing of the sexual violent predator proceedings. DCAs are in conflict. Case 6. Trial court denies the PC 1473.7 motion, reversed by the DCA. Written advisement and waiver was good. Verbal advisement and waiver was good. No claim of attorney incompetence. But defendant now states he did not meaningfully understand immigration consequences. Held. This is enough. Case 7. Trial court's questioning of prosecution's expert and the court's frequent interruptions of the defense cross-examination of the same witness cumulatively crossed the line and gave jurors the strong impression that the court agreed with the witness. Conviction reversed. Case 8. In response to a jury question during deliberations, court gives a common-sense dictionary definition to the word association as used in CalCrim 1401. Held. Prejudicial error. Association under PC 186.22b requires more than mere association. Case 9. After 30 years in prison and 10 parole denials, defendant, who was given life for kidnap robbery, files habeas saying sentence has now become cruel and unusual. Held. This is a proper subject for habeas and the proper time to raise the issue. Case 10. After 30 years in prison for kidnap robbery, defendant files habeas saying sentence has become cruel and unusual. DCA grants habeas and the DCA strikes the parole requirement. Supreme Court reverses the DCA only for striking the parole requirement. Case 11. Defendant is charged with killing a police officer while on duty. Long discussion of the issue of uniformed officers wishing to attend the trial. Trial court fashioned ad hoc but balanced solutions to the problem. Upheld. Closing arguments had a packed courtroom including 18 uniforms. Case 12. Victim was a police officer. Penalty evidence included 3 fellow officers / friends telling the jury what a good cop the victim was. Upheld. Case 13. Victim was police officer. Penalty evidence included a short autobiographical essay the victim had written about a particular event. Victim was a prolific writer. Court limited evidence to one essay. Upheld. Victim impact evidence is about telling the jury who the victim was. This essay did this. Case 14. In 2001, defendant gets 74 to life for crimes committed at age 15. Case is final in 2003. In 2018, Department of Corrections recommends a resentencing under PC 1170D because the court imposed both the gun use enhancement and the gang gun use enhancement. Court resentences. Held. Case is not final anymore. Defendant gets Prop 57 unfitness hearing. To download a PDF of all the summaries added this month, or to download the entire database, please go to our website at casebanklaw.com.